Hello everyone, this is Francis Chan. I'm glad to have David again at this episode. David.
Thank you, Francis. So today we're going to look at directors of companies in financial distress. So we look at their duties and obligations, potential personal liability, what disqualification orders are, and also what actions a liquidator might take against a director.
Welcome to this YouTube channel of K-Leaders. I'm Francis Chan.
I'm David Wong.
David, I have a question for you. My client are directors of insolvent companies, and he's very concerned about his risks and duties.
Thanks, Francis. To start off on that question, I think we need to look back at what the duties of a director are. So in Hong Kong, directors owe a statutory duty of care to exercise reasonable care, skill and diligence in carrying out their duties. And they also owe a fiduciary duty, that is a duty to act in good faith in the best interests of the company.
Okay, those are the very basic duties of a director.
That's right. So in a normal situation, those duties are owed to the shareholders of a company.
Yes.
But as a company enters into what's called the zone of insolvency, that's when there's a risk that it will be unable to pay its debts, then those duties are also owed to the body of creditors as a whole.
Okay. So other than duties, will there be any personal exposure for a director?
But this is another good point, Francis. As most people would know, normally directors and officers are not personally liable for the debts of a company. But as a company enters into insolvency, there are exceptions. In Hong Kong, well-known one is fraudulent trading. And that's when the trading of a company has been conducted with an intent to defraud creditors. That means there must be an element of dishonesty.
Okay.
Another situation is where there's unfair preferences. That's where the company has made payments to certain creditors ahead of others at a time when it was insolvent, or as a result of those payments, it goes into insolvency. Thirdly, if the directors have breached their duties, the duties we spoke about before, then they're also liable for misfeasance, and they could be open to a court order to make up those breaches personally. Finally, in Hong Kong, it's important to remember that there are potential criminal liabilities for certain things, such as failure to pay wages or make the mandatory MPF contributions. And a company suffering financial distress or being in financial distress is not a good reason to fail to make those payments. So that's very important to remember.
Oh, that's good for the employees.
Yes.
So what will be the worst scenario for a director?
Well, another potential risk, aside from those civil and criminal penalties, of course, is that a director is liable to a disqualification order. Disqualification order is a ban on that person from serving as a director of a company or being involved in the management of a company for up to 15 years. And it's not just a ban in terms of the company that's in liquidation, it's from all companies. And disqualification orders can be made under various statutes in Hong Kong, for instance, the Securities and Futures Ordinance, but importantly, it can also be made under the company's winding up legislation. And in this context, this director of a company that's been wound up might be disqualified if they've been convicted of fraud or another indictable offence, if they've breached some of those duties that we spoke about earlier, and finally, they are considered to be unfit to be a director, which is a more general ground.
Yeah, I understand that in insolvency situation, the liquidator has the obligation to investigate and to report to the official receiver office about the acts of the directors. If they fail to, for example, to keep the books and records, then they will be reported to authority, and then there may be disqualification order granted.
That's right, Francis. Indeed, liquidators, once they've appointed, have a duty to investigate the conduct of the directors. So in that sense, they'll look for the books and records and also the previous transactions that have led the company to go into insolvency. Additionally, they have further powers to conduct examinations They might be private examinations where where a director is compelled to answer questions, or the liquidator might seek an order to have public examination, which is an examination of the director or officers in a courtroom.
Okay.
Liquidators, of course, are also empowered to recover payments and unwind certain transactions. Those are the voidable transactions. And we've spoken about some of those a little bit earlier, like fraudulent conveyances, unfair preferences, transactions at undervalue. They can also attack at certain types of charges, such as floating charges, with a view to recovering payments which may have been made under those security. Finally, liquidators must report to the official receiver on the conduct of all directors of the company within the last 3 years. So it doesn't matter if you've resigned, a liquidator will be obliged to look into the conduct of all directors of the company.
I see. I don't think anyone would like to be examined or investigated.
It's not a pleasant experience.
And the past directors does not mean they relieve their obligations and duties.
That's right. So that's why it's always important to get assistance and to deal with these issues quickly when they arise.
Oh, I think this is always very important, to also recruit a competent advisor. So thank you very much for your sharing, David, for this time. What's the key point you want us to take away?
Well, I think it's what we just talked about earlier, Francis, and that it's always good to get assistance and get it early, because there are always more options when you act earlier.
Okay, act earlier, act quickly is still the key point. So thank you very much, David. So what will be our topic next time?
So we've just had a look at the position of directors in the insolvency and what will happen to them. So next time I thought we might look at what will happen to debtors and creditors. That's people who owe money to the company or that the company owes money to.
Oh, excellent and very useful. So thank you so much for watching, and see you next time. Bye-bye.
Bye.
Thank you for watching this video. If you like it, please give us a like and subscribe and share with your friends. Look forward to your continued support. See you next time. Bye-bye.